Welcome back to Season 6 of Inside Medical Malpractice. I'm Chris Rokosh, your podcast host, and I am so happy to be here today with you. And I first of all want to thank each and every one of you for listening in today. Without you, I wouldn't be here, so I appreciate it so very much. Today on Inside Medical Malpractice, we're going to be discussing one of the most powerful tools for managing both harm and liability in healthcare, communication. And not just communication, but effective, ethical communication. My guest today is U.S. Attorney Kyle Sweet, a nationally recognized thought leader with decades of experience guiding healthcare systems through complex litigation, through patient safety challenges, and risk management. Kyle has spent much of his career showing that communication isn't just about words, it's about building trust. He's helped defense lawyers, plaintiff attorneys, risk managers, and insurers find common ground, proving that transparency and collaboration, both before and after patient harm events, can change the legal and ethical landscape. From courtrooms to hospitals around the world, Kyle has taught providers how to reduce liability exposure and improve outcomes by talking and listening more effectively. Today, he's here to share those lessons with us. Welcome, Kyle.
Thank you. Appreciate being here.
I first heard of Kyle through Leilani Schweitzer, a previous podcast guest. You may recall from her TED Talks and the podcast that Leilani lost her young son, Gabriel, due to medical error, and has since focused much of her energies on building programs to help healthcare systems respond when unexpected outcomes happen, to respond with compassion, transparency, and accountability. She and Kyle collaborated on the recently developed course Certified Medical Harm Communicator, or CMHC, which has a specific goal of equipping healthcare providers and systems with the skills to communicate and provide support to patients and families when harm occurs, to empathize, to rebuild trust, and support healing. Let me read you a paragraph from the website that describes a little bit about this course. Our goal at Comms Corp is not to turn all healthcare providers into the perfect person to lead a disclosure discussion. Our ambition is to provide all healthcare providers the opportunity to be trained to communicate in a way that offers compassion and reassurance to a patient or family member while significantly reducing the anxiety and stress on the healthcare provider. I just want to read the last half of that sentence again, because this is what we are going to talk a lot about today. While significantly reducing the anxiety and stress on the healthcare provider. We often hear about how open, honest communication after an adverse event can help patients heal and can help reduce the risk of litigation. And we all know about the toll that these events have on healthcare providers. There's a lifelong fear of being sued, the weight of developing litigation-guided care, the stress that never goes away. But I personally have never had a discussion about this subject, about how the same conversation that helps patients heal might also heal the nurses and doctors who provided the care. Every experienced healthcare provider I know has a story. Something goes wrong, they were there. Their actions may or may not have contributed or played a role in any way to the outcome. Maybe, or more often not, there was a real conversation afterwards. Following that, the patient is transferred to another unit, to another hospital, or in worst case scenarios, to the morgue. A lawsuit might follow, it might not. But either way, for the healthcare provider, life is often expected to simply just go on without ever talking again about the incident, and never talking again to the patient or the family who may have been, just moments before this incident happened, they may have been there as their most trusted professional healthcare provider. I've taught thousands of nurses in conferences across the country, and I don't think in a single conference there hasn't been a nurse who's come up to me to share a story that happened 10 years ago, 20 years ago, 30 years ago. And there was tears in their eyes, and it's still so close to their heart. And it's very often taken them out of the area of nursing that they were so competent in at the time of the incident. So let's break this down today. Let's talk about, let Kyle into this fascinating intersection of law and healthcare. Take a look at the problem, talk through some potential solutions, have a chat to introduce this groundbreaking course that has the potential to change the way we think about communication and liability, and let's learn something. I am so looking forward to this conversation. You ready for some questions, Kyle?
You bet.
All right, let's get at it. My first question for you is, you spent decades working at this intersection of law and healthcare. What first led you to this space, and what kept you there for, you said, 29 years?
Yeah. So thank you for having me. I was a police officer before I went to law school. And when I didn't really have any necessarily plans to practice law, but while in law school, I took a health law class. And one of my classmates in law school, her father was a very famous physician. He was originally from Syria, and he had immigrated to the United States, in particular Oklahoma City. And he was a cardiologist and set up the first transplant center in Oklahoma. He had the patent for one of the first mechanical hearts, and just a brilliant man, huge ego. And he was a guest speaker in our health law class. And normally you would expect this guy would have come in with, acolytes and that kind of a surgeon personality. And instead he brought patients. And he brought patients who'd had life-changing experiences based off of their transplant surgeries. And law school was a cutthroat, competitive environment. I didn't enjoy it. But at that moment, I felt like, having been in law enforcement where I just key my mic and I've got hundreds of people rushing to help me, I felt like, oh my gosh, these are people I could help. I want to help someone like this. And so it really drove me towards seeking a job with a healthcare firm that represented healthcare providers. And because I'd been a police officer, my boss was like, okay, well, you can handle yourself. Go do this expert deposition. So I got to get in trials right away. And eventually when I had my own firm, I was able to recognize and have closer relationships with all of these healthcare providers and executives. And I began seeing case after case after case, the toll that it was taking on the healthcare providers themselves personally, their marriages. I did it long enough where I could see the years on impact of having an industry that exists to exploit a mistake. And we make it worse it's not like we're on the defense side, we're pouring gas on the fire by deny and defend culture. And and I got tired of looking in the eyes of these healthcare providers, and they knew something had gone wrong. Maybe they didn't feel like it was their own personal fault, but they felt the weight of the responsibility of the outcome. And I helped at the University of Oklahoma Health Science Center. I had a really terrible case it was a case of tremendous damages and very little liability exposure. And that case weighed very heavily on a group of physicians. These multi-practice doctors were involved, and we wound up establishing a peer support system. And for the first time, doctors had a mechanism with which to talk to a peer rather than a lawyer. Because I'm not their peer. I don't know what it's like to have someone's life in my hands in that way. And so I think being intimately involved in that construction of a community for physicians and healthcare providers to be able to speak to someone, as a peer, it really got me fascinated and think we can go way deeper than this. And I happened to be attending a conference for Ascension Care Management, and the woman Cheryl Callahan, who is the head of claims and insurance services for Ascension, happens to be Leilani's best friend. And Leilani was a speaker at this, and there are hundreds of lawyers there. And Leilani was once again brave enough to get up and tell her story and about her son Gabriel. And I found it incredibly meaningful. And Cheryl's someone who's a convicted person for communication resolution programs. And at that time, she was the chair of the Collaborative for Accountability and Improvement out of the University of Washington. And in further conversations, Cheryl asked me to be the first defense lawyer representative on that board. And now a good friend of mine, Jeff Catalano out of Boston, was the first plaintiff lawyer representative on that board. And I'm still involved with them today. And that's how I met Leilani, which was really life-changing for feeling like we now have a path forward that we can find a gap that has been left behind in healthcare, and we can construct a solution for healthcare providers to ease that anxiety. Because really, Chris, they don't know what to say when these situations happen. And medical schools and nursing schools, they do simulations and things of that nature, but to be in the room when it happens. And that's what specifically impacts nurses way more than physicians. A nurse is the first line of communication, and they feel woefully unprepared in what is usually a traumatic a series of events with family or a patient wanting information and they don't have it. Or maybe they have it, but they're feeling that institutional pressure from their employer not to share it, or they're confused or scared. How do I even say this? And so we thought this is an area that we can have tremendous impact. And so we formed Comms Corps and have completed the filming. And it's like you mentioned, it is a certification that they can have outside of their professional, RN or BSN or whatever, MD. Ours is designed for all healthcare providers. And so we wanted anyone from food service or physical therapy or a neurosurgeon to be able to have that skill set. And even if it's knowing what not to say, not causing further harm by saying the wrong thing to the person, and not the wrong thing from a perspective of liability management, but the wrong thing from a perspective of expectation management, or giving them wrong information, or letting them have rushing to transparency when you're really supposed to be communicating facts. And so we want to make sure that people have that training, and they're going to be able to display that with their certification. It's also a continuing medical and nursing education that's in all states at this point.
I think that is, well, first of all, thanks for that great story. When I first talked to Leilani about you, she said, we are kind of an unlikely pair.
Yes.
She said, we just have some kind of magic together. And she's so excited to be working with you on this course. And I just want to say thank you for doing it, because I nursed for several years, and labor and delivery mostly. I haven't seen a lot of bad outcomes, but there's been a handful of terrible outcomes. And there's only once when a patient actually came back to see me 2 days later on the unit where I was working and said, Chris, can we talk? I want to tell you how this all turned out. And only once in my entire career have I ever had the opportunity to go back. And I still remember, it still touches my heart today. But I'm right where you just said. I didn't know what I could say, what I should say, what I couldn't say. It was a bit of an awkward, stilted conversation, but still I was just so grateful to put my hands on her and say, I'm so sorry this all happened. I didn't have to admit guilt or liability, because whatever, it just was one of those bad outcomes. But I can only imagine that in developing this course, you had to have a very comprehensive understanding of the complex challenges the healthcare system face regarding disclosure and transparency and accountability. Can you discuss that issue, which I'm sure is a big one, both for the healthcare system and the healthcare provider?
Sure. And I just happened yesterday to be on a webinar panel with some other subject matter experts from the legal side. And one of them is Wes Butler, who I think is probably the leading subject matter expert, thought leader on the concept of privileged communications. And Wes had an incredible way of describing it, saying that privilege should never be used to withhold facts after a harm event. And if you think about it, it's kind of mind blowing. That's a simple phrase, but I think it really distills down the ethical situation that we lawyers find ourselves in. And I'm pretty atypical for defense lawyers, because most of them are like, and I love them dearly and have spent 3 decades in their company, but they know how to do one thing really well, and that is deny negligence and defend care, even if it's mediocre care. If it's care that you're not proud of, if it's care that may very well have caused the injury, but you got a patient with significant comorbid factors, then we blame the comorbid factors, and we win those cases a lot, because people don't like, historically, they like their healthcare providers, and they don't like people who sue. That's changing a little bit post-COVID in states where historically we've never seen, the larger verdicts. And I think that is ultimately a reflection of the way people view the lack of information they get in these lawsuits. And so I think balancing the obligation of healthcare providers to be transparent with the facts, regardless of whether there's harm or not, is paramount. And this is why I think it reduces liability exposure so much, to just be honest about what you know. And sometimes the truth is not subjective. The truth is an objective thing. And so I would coach witnesses to say, I want you to recognize when you're stating a fact. The temperature was 97.1 degrees. Here's the thermometer. I wrote it down. That's a fact. She looked feverish. That's subjective. Okay. And so when we're not dealing with your perception, we're not dealing with your opinions, because healthcare providers want to wait until they get as much information as they can in order to form their opinion. But when you're at the bedside with a patient, you don't have to wait. Waiting makes everything worse. Communicate what you know. Communicate the facts as they exist, not the way you perceive them to be, but the facts that they exist. There's never privilege associated with telling the patient what is going on and what has happened to them. And that to me is the key. I think we have to reimagine as lawyers, our explanation to our clients, our healthcare clients, and help them better understand the ethical obligations they have to make communication a continuous activity and not something that a mistake means we terminate any obligation to communicate with the patient because now we're concerned about liability exposure. The Hippocratic Oath is first do no harm. And if he'd have written more, he would have said, then continue to do no harm. And we continue to harm by denying facts to those patients. And I think lawyers who participate in that by scaring their clients into having any discussions with the patient in real time, they're doing a major disservice to their client, and they're not meeting their own ethical obligations to their client by letting them know what it is that they can and can't say. And so that's really kind of it in a nutshell, is ultimately that the physician, nurse, healthcare provider has an obligation ethically to continue to provide information to the patient. And a mistake does not exonerate them from that responsibility. In fact, it makes it even higher.
That is like a whole new way of thinking about a lot of things, isn't it? And I appreciate it so much. And I especially appreciate how you've distinguished the necessity to continue communicating facts without opinion or subjective observations. Because you're right, the facts are the facts, but I think so often, almost immediately after an adverse event, the fingers can start pointing and someone wants to assign blame or find fault. And so are you saying that that's what you need? You're going to communicate the facts, to carry on the conversation, tell the patient and their family exactly what happened, but step back from, am I getting this right? You step back from subjective observations and fault finding and finger pointing at that time.
Well, and I think you can be, transparency is really pretty simple. I think it was Mark Twain who said, telling the truth is simple. It's lying that's complicated, because you never have to remember what the truth is. And I think all the healthcare providers aren't lying in these situations. I think they feel burdened by giving a subjective opinion or a thought about what may have caused something, instead of just saying, I don't know yet. But we have a process that we're going to go through, and here's what that process is. And everyone from someone in food service to the CEO of the health system should be able to say that to any patient at any time if the patient may have been harmed by their care. And saying, I'm sorry that you're going through this, I'm terribly sorry that you have suffered in some way, is not an acceptance of legal responsibility. It's a reflection of your humanity. And I think one of the reasons Leilani and I get along so well is I'm someone who's naturally I have a bias for action, and Leilani has a lifetime of built up of impatience with the behemoth of healthcare changing in ways that benefit both healthcare providers and the patients. And so this is one of those areas that is incredibly frustrating for us. And Leilani coined a phrase that's called "communication is care." And why would you ever, if you stop communicating, you stop caring for that patient? And a mistake does not, like I've said a million times, a mistake does not exonerate you from continuing. It doesn't immediately terminate the physician-patient relationship or the nurse-patient relationship. It heightens it. And part of that responsibility is knowing, what to say to those patients in those situations. And I don't mean to get ahead of the cart here, but I think it's critical to mention this. And I've taken thousands of depositions of plaintiffs and their family members in my career as defending healthcare providers. And I, very early on in my career, I asked the same question, and it was just because I was curious, and I thought it might give rise to me having a better understanding of who this witness is, which I felt was my goal, to go back to the healthcare system and the insurance company and report, who is this person? Why are they here? Or how did they get here? And so the very first question I would always ask was, why did you sue this hospital and this physician or healthcare providers? And every single instance, they never said, not one time did anyone ever say for money. Instead, the answer every single time was, no one would talk to me. I couldn't get any answers. And that's just heartbreaking, because, and I do believe that, I've seen it when you have these conversations where communication is an ongoing thing, not a terminated thing for a patient. They just don't sue, and they just don't do it. They get their answers. They want, Jeff Catalano says, they want three things. They want answers, an apology, and assurances. They want an answer of what happened, what's going to happen next. They want an apology. They want someone to basically say, I'm sorry this happened to you. I apologize that someone made a mistake. And they want assurances that it won't happen to someone else. So the AAA is what people really, that's why they sue, because they feel they have no other way to get it. And of course, the very pillar, the foundation of that series of things that they want is answers. And they're owed it. I think healthcare providers owe information and answers to the extent that they have them. And if they don't have them, they owe the conversation of, I don't know that yet, but we have a process with which we go through to find that. It's called the CRP, or any other of the names that are used to associate communication and resolution programs, and tell that patient what's about to happen next. We have a process. I'm invoking that process, and I'm going to notify my supervisor, and I will continue to talk to you and let you know what's going on. It's not rocket science. That's the part that's so frustrating. It's, as an adult lifetime of doing this, it's like being a parent. The hardest thing in the world to do is to get someone else to act in their own self-interest. And that's what we're really dealing with here. It's like, it's a sense of, how do I get you to do what's best for you? And it's not me that thinks I'm trying to, put my expectations on top of you. This is best for you, and the system is just, the deny and defend culture and mindset is so strong. And it's mostly promulgated by people who were on the same side of the table as me.
You said a lot there, and it was great, all great, fascinating stuff. I think the two things that stuck out for me there are that it's good that everybody in healthcare knows how to have some version of this conversation, because certainly in a big mass emergency of some kind, there's so many people in the room, and everybody knows or has seen or witnessed some part of what's going on, or been assisting with a family or assisting with something. So it's good that we all know how to have this conversation. But how, it seems to me that this is the perfect solution. But what percentage of hospitals would you say are having these conversations, are going to adopt these open, transparent communication? Because I know I've been through lots and lots of training about how to handle it. And then we've all been on the same page, and everybody's hopeful. And then something happens, and it was very simple to revert back to where we just all came from. And it started with anger and blame and pointing fingers and backing off, and the patient and the family angry and uninformed. How, I'm not a doomsday sayer in any sense of the word. I appreciate and I believe in what you're doing, everything about what you're doing. How are we doing so far there, I guess? What's the report card on how healthcare is doing with open, transparent communication at this moment?
Great question. And the answer is not encouraging. We will have better data next year, and here's why. The Centers for Medicare and Medicaid Services in the United States, for the first time in 2025, has issued to anyone who's a plan participant provider under Medicare and Medicaid, which is pretty much about everybody in healthcare, that the systems have to make an attestation, and that means an attestation of whether they have a communication resolution program. Now, there's no consequence for them if they don't have the program. The only consequence is if they don't submit the attestation, then they can have a reduction in their in their reimbursement rates. So we will have much better data over what the number of hospitals and health systems have as far as a CRP. But I would say it's I would say right now it's less than 20%. I would say probably single digits who actually have leadership buy-in at the highest levels and have an ethical response to patient harm process that is staffed and by knowledgeable people with demonstrable results for patients and providers. That is probably something in like less than 5%. And here's one of the problems that we have with it is people hear CRP, and before you even when you start explaining what it is, like, oh yeah, we have that. And I was like, well, tell me what exactly you have. Yeah, we have a disclosure policy. Okay, a disclosure policy is fool's gold in comparison to a dedicated, ethically, responsible process of an actual CRP. And so, saying that you have a policy that, and how it allows you to disclose information to a patient is not the same thing as having a system that is a process that it is invoked when a patient harm event occurs. It is significantly different. And what happens even at hospitals who may have a sort of a CRP, when those bad things happen, there's no built-in process. So you don't rise to the occasion when patient harm events happen. You default to your lowest level of preparation. And in this instance, it's maybe a disclosure policy, but then the patient doesn't get any continuity. The healthcare provider doesn't have any continuity. It's just it's a policy that you wave around that makes you feel good about yourself as if you're some transparent organization. And in fact, it's not. Disclosure policy is not evidence of a transparent organization any more so than all the Fortune 500 companies. They all have the same thing. They're all ethically diverse, and they're environmentally conscious. It's like it's an oil company, and they claim the self-righteousness of being environmentally friendly. So, it's the same thing in healthcare. We have these bumper stickers we throw all over the websites, and we don't live them. And this is an opportunity to live them.
That's a great explanation and great answer to that question. So thank you very much, because I've always worked in hospitals that had policies, but never once had a really formal policy that got enacted the moment that some adverse event happened, and a system to follow. And certainly, as I said, the communication between healthcare providers sometimes got very adversarial, and the communication to the patient shuts down completely. There's, everybody's afraid to say anything. So I just want to say that I'm so happy that you've developed this course. And I want to say to all the Canadian listeners, because that's a big part, 40 to 50% of our listeners, Leilani has graciously offered to let me review the course as it's available. It's almost done, I understand, Kyle, right? Were you thinking maybe October, November 2025, it might be ready to rip? So Leilani has offered to let me review the course and take a look and just be sure it's suitable for Canadian healthcare providers as well, and for Canadian CNE credits or continuing ed credits as well. So I'll be doing that in the next couple of weeks as these things get finished up. We've talked quite a bit about patients and the toll that these adverse events take on in the stopping communication, how it can lead to litigation. Let's shift now to talking about how this affects doctors and nurses after an adverse event. I'm so fascinated by that, being a nurse and by talking to nurses in my whole career and being part of lawsuits that took the reason I got into this medical legal work in the beginning is I was taking a course in university, and I wrote a paper on litigation stress in doctors and nurses, and sort of the motivation, how nurses feel guilt after an event and doctors feel loss of control, but we all feel this ongoing forever sense of dread, and sometimes to the point that it takes you out of healthcare, sometimes to the point that it shifts you down in responsibility or acuity in your healthcare practice, and sometimes to a really safe job, like a ICU nurse might take a medical clinic job. Not that those aren't both incredibly important, but she'll just not be able to handle the stress and the risk that comes with ICU nursing anymore. But talk to us a little bit, because this was fascinating me about this course, is how it has a dual goal of healing patients and healing healthcare providers. Let's hear what you have to say about that.
Yeah. So, there's only one thing we all have in common anymore, and that is we're all going to be patients of the healthcare system. It doesn't matter what political party, what country you're in. That's the only thing that we really truly have in common is we're, and so that's kind of the attitude I think I've developed over the years when it comes to healthcare providers, because I've gotten so close to them, and I have so many dear friends and family in healthcare. But one quick example, I tried a case. It was a brain injured baby case, and it was an OB-GYN, and it was allegations of issues of how the prenatal care was managed in relation to the mom thinking she had cytomegalovirus. And so the child was eventually born with, and the doctor, did everything that you would do. She had a genetic evaluation of the child. She sent the patient to a maternal fetal medicine specialist. So the doctor really went above and beyond, and the child was born significantly neurodeficits, wheelchair for the rest of his life, probably a shortened life expectancy. And the family was just so devastated that they filed a lawsuit. And a lawyer from Baltimore came to Oklahoma City to try the case. And I happened to be friends with the OB-GYN because my wife had been a college sorority sister of hers. And so we win the case. It went on for a couple of weeks. One of my best friends, who is a pediatric heart surgeon, had died that week of trial after a long battle with lung cancer. And so I gave a eulogy at his funeral at the middle of, so we had the funeral literally in the evening so I could attend, and gave a eulogy the same night I was preparing cross-examination remarks over this family who was suing because they wished they'd had information so they could have terminated their pregnancy. And that experience, so we win the case and we go out, we did what we always do. We would take the doctor, the rep from the insurance company, and we go to a bar, everybody's exhausted and we're, toasting this doctor. And because I knew her, so had known her for years, the look on her face, what she wanted to be anywhere in the world other than right there with us, and it was, I started just looking at their faces, and not, and just seeing the devastation that she was experiencing. And it obviously she felt terrible that one of her patients had a child with neurological compromise. She didn't feel that it was anything that she had done that caused that, but she felt terrible for this woman. And to sit there for 2 weeks while people fly in from all over the world and say how you were negligent and you caused this, was cumulatively just very destructive on her health. And I could see it. And it just started making me realize that the toll, every single case involves this. It's not, there are some, surgeons who just get sued so many times because, that's what happens, or, and they've got the fighter pilot personality and they're tough guys and gals, and, they try to act like that doesn't bother them, but it does. You start out in the world thinking it's really, I view it as there's a death involved for a healthcare provider, particularly for physicians, when you're named as the party in the lawsuit. And that is, they go through the process of grieving someone, and they're grieving for the person they thought they were, who was incapable of mistake. And then now they have this reputation. They have to report it every year. They do their re-up for their privileges at the hospital, or every other year when they re-up with their medical board, they have to report this, describe it, state the outcome. And so it really cumulatively, it wears on them. And I think I've seen that personally. I've seen a surgeon quit a successful surgical practice and go back and become a psychiatrist. I've seen physicians leave, after years and years of grinding, grueling residency and fellowship training, because the risks of being sued and experiencing that again, they want to mitigate it any way they possibly can. And so I think it's the same, even if you're tangentially involved in a lawsuit, like what you would typically see with nurses. And nurses are the ones who really are there because they're empathetic and they want to help people. And when there's a chance they may not have helped, even if they didn't harm the patient themselves, it's they carry that with them, and I just think that we do a terrible disservice by when someone has made a mistake and wants that healing for the patient and wants to be able to learn from the mistake. We wind up we put it in a silo. We don't talk about it. We don't study it. We don't try to improve from it. We just manage that, and that's not the way you should be ethically treating the people who work in healthcare.
I love what you just said, and I don't even think sometimes it's managed. The stuff that I've been involved in where there was a really bad outcome, I never had a decent conversation about it again. In fact, I was told to not even discuss it with the people who'd been there, other than maybe a short debrief, 15 minutes or an hour after it happened, where everybody's exhausted and overwhelmed. Anyway, I just happen to have this book sitting here on my desk because I always have it. And this is by Dr. Danielle Ofri, who's been a guest on the podcast twice. And it's called When We Do Harm. And it's a whole book on the experience of the physician after they've caused, or all healthcare providers, when they've been involved in a situation where harm has come to the patient. And she really talks about how, as a healthcare provider, it becomes your identity. It's never your job. You are a nurse, you are a doctor inside and outside the hospital, with your family, with your friends, with your neighbors. I get called so many times, but I know lots of stuff about lots of people because they feel very comfortable, unloading and sharing their prostate issues with me and all sorts of other things. But I just want to thank you so much for bringing this to the forefront, but not just bringing it to the forefront, but doing something about it, like finding a way that this open communication can heal. Because I think you're right. When you're in caring mode, especially nurses, when you're there at the bedside and you're taking care of a patient and literally sharing every single part of that experience with them, and then all of a sudden you're told to be quiet and back off, or you're so uncomfortable approaching that patient or family again because you have a sense of guilt and responsibility or fear, whatever that is. I think I have great hope for this course, and I wish I'd taken it 40 years ago. And
well, thank you. One thing I do want to make a point about, Chris, is you hear some people say describing a healthcare provider as a second victim, and we don't agree with that. But I think that doesn't mean that they don't carry, moral injury by having experienced this. They do, absolutely. But I think it's important to respectfully address a concern on the patient side and the patient advocacy side. Is how dare you? You're a victim because you harmed me, and so you're now claiming the same status as I am. I didn't make a mistake. And so it's we just to be completely transparently, uh, respectful to the patient side. We don't use the phrase second victim. We want people to stop using that phrase, and we want people to recognize that that yet, though not a second victim, it doesn't in any way belittle the fact that there is a moral injury to that healthcare provider, and the anxiety and the stress and depression that they experience is palpable, and they need to be able to have a way that they can address that and respond appropriately for their own wellness.
Yeah, thank you so much for bringing that up. And I love how your course, when I read that opening paragraph, it does say, first of all, to heal the patient and their family, and a byproduct of that is to heal. So thanks for bringing that up. I hope nobody listening thinks that we are underscoring the effect on patients and their families, because that's what this is all about. And certainly, I think healthcare is at the core of both of our hearts in many, many ways. And I think all of us understand what you said earlier. We're going to be a patient someday, or our families. I have a daughter that's expecting a baby any second, and it's a vaginal birth after cesarean section, which sadly I know the good and bad possibilities there. And we just all, when you talked about the three things that you said patients want, the three A's, I've read that from nurses, all they want is respect me, take care of me, and please don't harm me. And I read that years ago, and it's always It's always, we don't have a Hippocratic oath like the physicians, but I think it applies to all healthcare workers.
And it should, for sure.
Yeah, for sure. So one of your unique approaches, which caught my attention, was bringing together defense lawyers, plaintiff lawyers, attorneys, risk management, insurers before harm occurs. Why is collaboration so important, and what changes when those groups actually work together?
First, let me say that I've fallen in love with this. The Onion, is that satirical, like fake journalism site, and there's a meme they share that's of a ram, and it says basically, ram will stop banging head against wall when banging head against wall stops working. And that reminds me, it's like, because that's basically what is impacting the legal profession right now in the United States. And that is, we have all these ethical standards we like to say that we have, and then we have such an incredibly weak judiciary when it comes to enforcing civil discourse and treatment between lawyers. It exists on the plaintiff side, it exists on the defense side. No one's, and I think it significantly ultimately impacts patients, because the reality of a situation, if you're in litigation, it is very it's very stressful for the lawyers too, and for a plaintiff lawyer, they have likely paid all of the expenses of the case in order to be able to make a contingent fee on a recovery. And so there's a lot of financial anxiety that can come with that, and there's a lot at stake. And when there's a lot at stake, there's also means that you're more apt to cut corners ethically and do things and treat other people in a way that is dehumanizing. And I've witnessed older male lawyers be incredibly disrespectful to young female lawyers. And I have a daughter who's going to law school in a year, and I think back at the way that knowing the way she could be, she doesn't want to do litigation, first of all, but knowing how young women could be treated, because they're empathetic, they're talented, yet at the same time, they're also, perhaps not as emotionally resilient because they've never been around conflict like this before. And so it's these tactics of abuse of the discovery process, abuse of other lawyers in depositions and in meetings and emails and phone calls is something that has created, and I know it's a long way around the barn to kind of get to answer your question, but essentially it's incredibly difficult to have a trusting, collegial relationship with everybody on the other side. And so some lawyers, the problem is it works for them. If you're a lawyer that uses those tactics, verbally abusive and disrespectful to young attorneys, it works. You get in their heads and they try their case differently because they're trying to beat you rather than try to message the case the best. And so there needs to be some significant legal reform in the context of ethical behavior of lawyers in litigation. And judges talk about it, and they go to these conferences, and they all basically pat each other on the back, and they get in their courtrooms, and they just don't ever take action. So that's a long time frustration point of mine. And so I thought they're not going to do anything about it, so I'm going to have to do it myself. And so proactively going out and establishing relationships with plaintiff lawyers, it got me to the point where I have gone to health systems and told them, here's what I want to do. I want to bring a plaintiff lawyer in. I want you to invite the 10 most frequently encountered plaintiff lawyers, and your 10 lawyers who get the most assignments from you on your defense panel, and we're all going to get together and talk about communication resolution programs. Like, we can't tell them about that. And I was like, then if you don't tell them about it and turn them into an advocate at the onset, now you're gonna wait and do it when it's an incredibly stressful, anxious situation and the patient has been harmed. You can't. That's the wrong time to try to say, well, I'm going to turn them into an advocate of it. Let's do it in advance, because they're going to be able to have a better understanding. They're going to be more apt to reduce their fee, so they can, because they understand they're going to get to a quicker resolution. We can build trust with them because they're going to see that we really want what's best for a patient, their client. And I think it puts them in the situation of I think that they're surprised that this is going on, and they feel flattered and anxious a little bit, nervous and not, and I should say wary of what we're doing. But ultimately, you have to continue that all the time. And when we've seen that, you see they're not. It's like watching two guys go to a movie theater. They're going to sit as far away from each other as they can. That's what it was like in these rooms. But if you pick the right people and you just let them know, it's like we're not enemies. We're officers of the court, and we have ethical and moral obligations to each other and to as well as to our clients. And let's have a better understanding of what those are. And so we can understand where the other person is coming from. And we need to let them know that this is that way we're going to handle medical harm now. And some of them will miss, and some of them, if you find out that if someone comes to you and says, "Hey, I didn't say anything, but I think they made this terrible mistake," please let us know. We want to change the culture, and we want to learn from our mistakes, not be like a cat with a litter box and cover them up. We got to talk to them.
And has that so far been successful?
Yes. When it's continued after we leave, when the lawyers in that who are doing the work in that facility become learn and about communication resolution programs, if the hospital is truly embracing that at all levels and employing that, then yes, all it takes is one CRP, and a plaintiff lawyer will be convicted that this is the right thing to do. And it's just, and now they trust you, even if you had a history. And if you say, we don't want to do it, we want to do that anymore. We don't want to have this deny and defend thing. It's terrible business, to drag it out and then pay the money, which winds up what happens. And we grind our caregivers through the litigation process on things that should never have been litigated. And we grind that family through it all over again. And then what, we're going to write them a check and expect a thanks? It's unrealistic. Let's just. It's so much easier and cost effective to do the right thing when the wrong thing happens.
Your last sentence there was perfect. Just doing the right thing. I love that approach, and I want to applaud you for taking it. I'm just imagining the 10 plaintiff and defense lawyers or the defense lawyers or the plaintiff lawyers in the room, and absolutely not holding hands and sharing their popcorn at the movie. But I'm really glad you're doing this. And I think, I guess it's too much to say that this is what everybody wants, but I would think this is what most people want, right? This doesn't have to be such an adversarial, long, drawn out process. And it just seems there's some level of acceptance. I talked to a lot of attorneys, plaintiff and defense, and there's just a level of acceptance that this is how it goes. But I really appreciate the fact that you're breaking into that and saying it doesn't have to go like that. Let's come up with a better way. So thank you.
Really, it's not like we're inventing anything. This is just what we're supposed to be doing anyway. It's in the canon of ethics and the code of ethics. This is what we're supposed to be doing anyway. It's just like I come back to this thing. The hardest thing in the world to do is to get someone else to act in their own self-interest. So that's what we're trying to do.
That's good, and good luck, and thank you for doing it. Do you have a story that you could share with us that illustrates how this type of transparent communication changed the trajectory of a case or a patient-provider relationship, or just ease the pain of the people involved?
I do, and it was one where I will say this was more of an. I had a case where there was a represented psychiatrist who was being sued it was not. This case never was litigated. A young man who had a long-standing history of mental illness was. It was just a terrible tragedy. He attempted suicide, was institutionalized, and the psychiatrist who was responsible for managing everybody's care gave an order of every 15-minute suicide prevention checks, and so there are cameras everywhere. And that day, the mental health RN had just come back to work after being on a bereavement leave because his spouse had died after a battle with cancer, and so he was not fully there. His mind was still elsewhere, and he saw there's two young men who were there, and he saw them at the group, and they resembled one another, and so he got them confused in his mind which one was which. And he saw that guy sitting there for a couple hours in the group area, and meanwhile the other one had gone back to his room and had hung himself in the shower. And so the father worked at a neighboring hospital, and the sister worked in the same hospital where this mental health unit was. And so we knew it was a mistake from the beginning, and we knew immediately because that nurse was like, I thought that was, whoever the patient was. And it's like, no, that's a different patient. And we were called out within hours, and we we reached out to the family, and eventually they did not want to hire a lawyer. The father was incredibly, to say he was angry is an understatement. Understandably so. There was a dynamic in that family that was hard to overcome. He was not going to be told what to do by a lawyer, and I had to talk to him. I talked to him for weeks and weeks, and bore the brunt of his anger. And that was because I was paid to do it. That was my job. And it was, we had it got so bad when we did have a mediation, we actually had a plainclothes campus police officer attend the mediation with us, because there'd been all these threats and everything like that. And the guy was just expressing this terrible anger, and probably a lot of it was directed at himself. And it was easier to direct it, deflect it to other people. And we got to the mediation, and we had an excellent mediator, and we came in and we didn't do what dumb insurance companies do and say, we'll start out with $25,000, or start out by saying, he was probably going to kill himself anyway. We just went in there and said, what we did, we made this terrible mistake and it resulted in your son dying. We took the burden of making excuses for our mistake, or degrading the son that he's now mourning by saying, there was lots of stuff wrong with him. He didn't have a job. The things we do from an economic standpoint of evaluating someone's claim. We just went in there and said, we're going to pay what we think is a fair amount to compensate this family for something that money can't even really ever accomplish anyway. But it needs to be respectful, and it needs to be a significant number that right out of the gate. And we did, and the case settled in just a few hours. And I feel like we did our job as lawyers and healthcare providers for that family, because it was completely different. And they continued to their jobs at a neighboring hospital, and the sister continued to work at our facility, and they felt respected. And the case never resulted in litigation. And the psychiatrist, who was thinking, man, maybe I should have put him on constant, watch, and she was able to just put it behind her and go, this is one of those terrible tragedies that happens, and then really there's nothing I could have done about it. But if that had been a litigation, I would have, she would have continued living with that for a couple of years. So that's a situation where that was kind of before CRP started becoming a thing, and that was where you kind of had to have these happy accidents where, we'll do the right thing in this situation, or in managing the things for my client. Since then, I've had numerous instances. I mean, dozens and dozens and dozens of cases where, you get in early, and and I will say this, if the families feel like you're lawyering up, I don't go in there and have these conversations, nor should I. A lot of times what happens is lawyers can screw it up on the defense side, because everyone in that hospital is used to a lawyer saying, we can't do that because of the risk of increasing the liability exposure. When in fact, communicating with the patients reduces the likelihood of liability exposure. So what happens is we come in there and we kind of hijack the process, and winds up where you don't get the type of communication that the family really needs, or that the healthcare provider benefits from, and you wind up kind of poisoning that process with the deny and defend mindset. And so I believe that whoever is going to represent that hospital in a medical malpractice case has no business participating in any way, shape, or form in the CRP process. I think, and what I've encouraged, and I did it on a webinar just last night, I think you should have a separate attorney on your panel that is just your patient safety, quality, CRP, attorney. And so they're never going to be the ones making the disclosures and having the direct communication, but they can advise their client on the things necessary to resolve that case and the legal issues that come with that. But it's just lawyers getting involved gives everybody the excuse to not do the right thing, just to be blunt.
I appreciate your bluntness, because you've got experience. I know you know what you're talking about. I just want to say that story just touched my heart, as terrible as the outcome is. I'm so grateful for like the fact that the sister continued working in the healthcare, like the family stayed in that system, and that people found some level of closure with that terrible, terrible thing that happened. So that's a great story to share with us. Do you have challenges, um, in your role as mitigating the damages? Like, how do you overcome the let's walk in and offer $25,000 and versus let's walk in and offer them fair compensation for what's happened? Do you get resistance from the insurer or whoever it is that's retained you to represent?
Yes, and it's, I think it's changing in larger loss cases. It is a little bit of a different world than like a dental malpractice case where the average case may settle for $30,000 or something like that. But even then, I've had cases where the insurance adjuster wants to come out with like it's a operated on the wrong tooth case. You extracted the wrong tooth case, and they want to offer $500 to start. It's like the older I've gotten, I've lost my patience with that. It's like, what are you willing to pay? And I know they're not going to tell me what they're willing to pay typically, but if you're going to pay 10 grand on removing the wrong tooth case, then and you want to see if you can save a little bit of money, which I get. It's economies of scale. You save $2,000 or $3,000 on 200 or 300 cases, and you're doing your job. But if you're willing to pay 10 and you want to try to get it done today for something between like $6,000 or something, then we'll come right out and offer 4,500. That why I don't understand why anybody would make an offer that they're not willing, that the knowing the other side would never take it. And I think it's disrespectful. I think it's disrespectful to the insured, the healthcare provider, and it's disrespectful to the lawyer and the other lawyer on the other side and the patient. But it's a tactic, and good luck changing that. But I think on the larger cases, I think what we're seeing is plaintiff lawyers obviously usually start it, and I have taken the tactic of why do we need the plaintiff lawyers to wait on them to send us this convoluted large demand? Why don't we just come out and say, we can evaluate this. We know what these cases are like. We have all of the person's medical records. Let's just come right out and make them a really nice, respectful offer right out of the gate. And I've seen it even in contentiously litigated cases. Because the lawyer's preparing his clients for mediation or settlement discussions by saying, hey, get ready. They're gonna say all these terrible things, and they're gonna be disrespectful, and we're gonna have to fight. And you get in there, and it's like the first offer you get is like, oh wow, that's respectful. You remove all the heat and the fire right out of it, and then you immediately, but you're jump to where you would be hours later. And what happens now is most cases in the large cases aren't settling at first mediation; they're settling at the second or the third. And it's just they lose the opportunity to settle the cases when they can when they first can, by always putting more and more responsibility for information on the patient's representatives. And I think that we have all that information, so I think that's something that I hope to change. And I know there are people. I have a really good friend, John Hall, who's the principal at Hall Booth Smith out of Atlanta, who tries a lot of cases nationally. And John's one of those guys he's been doing that for a long time. And he's obviously very frustrated with the amounts that the plaintiffs are demanding, but he has a good strategy of putting a number out that's respectful in a way that really creates a level of trust and respect on the side of the patient and their family.
I can only imagine that it feels better for you too, does it?
It does, absolutely.
Yeah, to start respectful out of the gate, acknowledging the injury and the damages and the toll it's taken on the family.
Because we're not buying a car, where the farmer walks in, and I grew up on a farm, and my grandpa would walk in and, I'll give you $500 for that truck. It's like, it's a $20,000 truck, but it's like, you're not hurting that salesman's feelings. They're just going to laugh at you. This is something totally different. Yes, it's a marketplace. I wanted to try to purchase your rights to continue to sue me. But it's involving so much more than just numbers.
Yeah. I just want to say thank you again. I mean, Leilani, in her first TED Talk I ever saw, talks about how a revolution is needed in this whole process and the communication and everything that happens after adverse events. And I just feel like you're one of the revolutionaries here. Like you're one of the guys who's turning this great big ship around or trying to. I realize it's a big job and probably a lifetime of work for you. But thank you. I'm appreciating it. It's warming my heart to listen to you talk. Thank you very much.
Well, thank you. And there are many, many advocates out there. And if people are more curious about the communication resolution, process, I would encourage them to go to it's the Collaborative for Accountability and Improvement, and it is based out of the University of Washington. It has joint venture programs with the Ariadne Labs out of Brigham and Women's Hospital and Harvard. It's got Johns Hopkins and the Armstrong Center for for Patient Safety. And so, but Tom Gallagher is the executive director of that, and he is, from an academic standpoint, literally kind of the dean and one of the only 2 or 3 people in the world who really started this whole conversation many years ago, and has published numerous. So there's a lot of really good data out there, and there's a lot of free information on the collaboratives and their resources, webinars, and things of that nature. They can really get a really good idea of how what we're seeing is that, and the data is becoming more clear, that when institutions do this, there's multiple benefits to it. I mean, just forget about doing the right thing to the patient from a business standpoint, from a physician and healthcare provider retention standpoint, from a wellness standpoint, from a financial standpoint. There's every reason to do it and not a single reason not to.
Well said. Excellent point. And thanks for bringing up that, pointing to where references are. And let's talk for a little bit now. We've been talking for over an hour and it's gone by like 30 seconds for me. But let's, I don't want to miss the opportunity to talk about the Certified Medical Harm Communicator course before we go. Just tell us what's, without giving it all away, what's in it and what people can expect to learn. And, I think it's due soon. So let's get people kind of worked up about this course.
Well, first of all, I assure people it's a whole bunch of Leilani and a little bit of me, so that should make everybody feel better about it. And essentially, it's a 4-hour course that is broken down into segments that are digestible and walk people through the historic, ethical responsibilities that we have to patients, and walks through the history of CRPs. What is an effective CRP, and then mostly centered around how to have really difficult conversations with a patient at a point in time when it's really challenging for them to retain the information, and what you can say that gets through. And you have to repeat a lot of this over and over with patients because they're going through a tremendous stress. They could be on medications. There's a whole bunch of factors that Leilani goes through and really turns someone into being what we hope at the conclusion of the program. It doesn't, you're not guaranteed to be, all right, I'm the person who will handle all of our disclosures. That's not what this is trained, because not everyone is the right person to be having that particular conversation. But everyone can come through this program and be an advocate and understand within their organization what is supposed to happen and what makes sense to talk to people and how you say it. And so that's the real, we believe we want this to be a force multiplier for institutions that are going down the road of developing CRP programs, because it literally, we want people to be, you're going to be the person on your shift people are going to come to. You're going to be the touchstone from ethical conversations with patients and what are our obligations to continue to communicate with them facts, things that we know and things that are about to happen next, and remove that institutional fear that when a mistake happens, no one can talk about it. We don't even acknowledge it. And I hope the lawyers don't ever want to meet with me about it. And we're trying to basically let people have the skill sets to knowing what to say to patients at the time when they're at the bedside. And we want this program to be for the people who are encountering the patients the most. The housekeeping, the food service, the nurses, the nurse aides, the unit secretaries, the people who are dealing with the families all the time. yes, physicians, that would be great too. We want them involved and they can get the continuing education and get reimbursed for it from their employers. But ultimately, we want people in those hospitals who know what their obligations are to patients, and they know how, and are prepared to meet them when the time comes. Because I'd say you will not you will not rise to that occasion. You will default to your lowest level of preparation, and we're representing the preparation necessary to not make it worse, and how to be respectful to what that patient is experiencing, and knowing that you're going to be able to help.
That's a great sounding program. Can healthcare providers take this and use the information that they learn plus or minus buy-in from the healthcare facility? Again, I'm talking about, go back to that question I asked a little while ago about the challenges of healthcare systems facing disclosure and accountability, and how they've instructed their staff or what their policies or programs may be. If a healthcare, is this plus or minus buy-in by the healthcare facility or system itself?
That's a great question. And one of our, it's easier for us and way more cost effective from a business standpoint to market to our institutional, Rolodex. I'm old, so I can use the phrase Rolodex in here, but it's basically, Leilani and I have a lot of connections nationally with large institutions, and it's easier for us to go to them with the credibility that we're fortunate to have built with them and say, we're deploying this, rather than spend all the money on a direct marketing campaign to try to reach, the millions of nurses in the country, or the, millions of physicians in the country. So that's what that is the marketing efforts that we're doing, is we're going to the institutions, and we hope it's going to be a top down, and they'll go and be able to buy bulk sessions, for their members, and then they can pass the code on to whoever in, their employment org chart they want. But it will be available for any healthcare provider that wants to just come directly to the site and access the certification program. It's 4 hours. It's not, you can finish it on your own pace, and you can put those initials on your badge, and it represents the fact that you are someone that people can come to when harm occurs.
That's a great way to approach it, top-down approach, because I think it's a great program, and I hope it gets widely adopted. And I'm going to take it, and I'm going to get the badge. We've been talking for a good long time now, and I've enjoyed very much every part of this, and I so applaud the work that you and Leilani are doing, and a fresh approach to an old problem. And I have one question I ask everybody at the end of the podcast, and I'll ask this to you, that if you could leave, and I'd like you to answer this for 3 different audiences: patients, attorneys, and healthcare providers. And maybe the answer is the same for all 3, I don't know. But if you've got one takeaway from this conversation today, what would it be?
Well, for healthcare providers, it would be communication is care. It's an ongoing responsibility, and nothing can terminate that responsibility unless the patient says, "I don't want to talk to you." Then you have to respect what the patient's boundary that they have, and that happens on occasion. If someone feels the healthcare provider's trying to buddy up to me after the mistake or whatever. But ultimately, just the concept, communication is care, and it's an ongoing responsibility. And to lawyers who are an equal, I would say, learn more about it, and look deep within yourself, whether you're a plaintiff attorney or a defense attorney, and recognize if this is really in the best interest of my client, and I know that no one can disagree with that, then, then you need to become a subject matter expert on it and have a better understanding of the ethical obligations that your healthcare provider client has. And for the plaintiff lawyers, you have, just because a hospital is coming to you wanting to resolve a harm event early, that's a tremendous opportunity for you also to learn about this process, become an advocate for it within your community of plaintiff attorneys, and reach back to the other side. Go to lunch with an attorney from the other side. Develop, if it's easier to have a trusting relationship with somebody you've broken bread with. And then lastly, to the patients, I would say, when you're selecting your healthcare providers, inquire about whether they have a communication resolution program. Now, not like going to your doctor's office, but if your doctor is employed by a group, large physician group or health system, then inquire. You can find those things online, and you can ask. If a mistake is made, how does your institution handle this? I would imagine most Americans or Canadians would get a response of blank stare, like, I don't know, and ask, because ultimately, anyone who goes into healthcare as a patient, you have to become your own advocate, I just think it's critical to write things down, ask questions, and when you don't get answers, insist on answers, because what happens, and this is, I'll end with this, and we didn't get to talk about it, and this is, I think, an incredibly important way in which to understand what happens when patients get upset naturally. If someone had harmed me or one of my kids or my wife or my mom or whoever, I would be upset about that. Naturally and understandably upset about that. I might even be irrational. I probably will get to the level of anger. I probably will not say words I would want my church-going grandmother to have heard. But what happens on the healthcare provider side and the attorney on the healthcare provider side is that patient has just given us permission to weed and say, see, you can't talk to these people. And so it's this vicious cycle of we create the problem, and then we use the reaction to the problem to avoid having any responsibility to continue to care and continue to be involved in that person. And so that has to change, and we have to recognize that when somebody's been harmed, they're naturally going to be angry and upset. And the only way you address that anger and that upset is by communicating with them, sitting down, listening to them. And that's what has to happen. Instead, in healthcare, it's like, whoops, no, we're done. Circle the wagons. It's defend time. See, we can't let our healthcare providers talk to people like this. They're sending these terribly worded emails. It's like, yes, they're upset, and I would be too. So that's the kind of the final takeaway I would like people to understand is, and for healthcare providers and for patients to understand that, they may cut you off, but keep trying.
That's one of the best ending pieces of advice I've ever had on this podcast. Thank you so much, Kyle. That was great. Because I think learning how to anticipate that anger and just sit with it and deal with it and communicate through it, but to anticipate it, not be scared by it or surprised by it or get run off by it. Because you're right, it's a perfectly 100% natural response to what's happened. So thank you. Thank you so much. I think we'll end things there today, although I feel like we could have lots more to talk about. But I just want to thank you for sharing your insights on this important and, for me, a very mind-expanding topic to look at the angle of how a conversation heals everybody. So for those of you listening, whether you're a healthcare provider, manager, lawyer, risk manager, patient, advocate, insurer, the Certified Medical Harm Communicator course will be available before long on commscorp.com. And thank you, Kyle. It's been an absolute pleasure having you here.
Thank you, Chris.
And to all of you listening, thank you once again for joining. I'm so glad that you take the time to listen in. If you enjoyed today's episode, please like, subscribe, and leave us a review. And don't forget, as mentioned in previous podcasts, in many jurisdictions in both Canada and the US, nurses, doctors, and lawyers can earn continuing ed credits just by listening. And as always, we're on all the obvious podcast places, but you can find resources and past episodes on our website at connectmlx.com and on the Inside Medical Malpractice YouTube channel. So tune in again next month for an episode you won't want to miss. And goodbye for now, and take good care.